The expansion of litigation finance is drawing more attention from state and federal regulators. Until now, there has been a patchwork of statutory and other regulations. But more and more legislatures and regulatory agencies are considering ways to regulate litigation finance transactions. For many years, litigation funding was entirely banned. With the last few decades, that ban has eroded. Today, about half of United States jurisdictions permit third parties to fund litigation more or less freely. Even where it is permitted, the sources of regulation for litigation funding can be diverse. In most jurisdictions, litigation funding is not characterized as lending. But, in some states, regulations come from the usury laws that apply to consumer lending. Of course, these regulations might not apply if the party receiving funding is a business entity. Other regulations pertain to disclosure. For example, Wisconsin just enacted legislation requiring the disclosure of litigation funding arrangements. Some courts, such as the Federal District Court for the Northern District of California, require disclosure of the participation of litigation funders in certain kinds of cases. But even with these disclosure rules, there's still some uncertainty over the extent to which the attorney-client and work product privileges protect funding arrangements from disclosure. Given this variety of regulatory sources, some litigation finance firms have considered uniting to develop and propose a set of disclosure and other rules that they can live with. As litigation funding continues to grow, the effort to regulate it will increase. And funders are probably well advised to participate in its formulation. If you need help with litigation funding, call or email me today.